September 1662, Charles County, Maryland. A 23-year-old indentured servant named Elizabeth Greene stands before the provincial court clutching a newborn infant. The court recorder's pen scratches across parchment as she names her master, Robert Clocker, as the father. The judges don't question whether she consented. Instead, they add 2 years to her servitude contract as punishment for fornication. The baby is declared the property of the man who impregnated her. The question isn't whether this happened. Court records prove it did. The question is how many Elizabeth Greenes never made it to a courtroom at all. The archives of colonial courts from Virginia to Massachusetts contain thousands of bastardy cases involving servant women. Historians Kathleen Brown, Sharon Block, and Terry Snyder have spent decades extracting these stories from court dockets, plantation ledgers, and parish registers. Today you'll discover why the servant trade created a built-in system for sexual exploitation, how colonial law punished victims while protecting predators, and the evidence hidden in birth records that reveals just how widespread this abuse became. Every detail comes from documented cases. This is what the receipts show. The system began with desperation on both sides of the Atlantic. Between 1607 and 1775, approximately 300,000 Europeans came to the American colonies as indentured servants. Most signed contracts they couldn't read. Thomas Hellyer, who arrived in Virginia in 1627, later testified he was deluded by a spirits merchant in London who promised him 20 acres and plenty of food. The contract he actually signed bound him for 7 years to a master who could legally whip him, sell him, and control every hour of his existence. The Virginia Assembly's 1643 statutes made it explicit. Servants were property during their term. They could not marry, leave the plantation, or refuse orders without risking additional years added to their contracts. Women faced this same system with an added vulnerability. They arrived outnumbered. In 1625 Virginia, men outnumbered women 4-1. By 1650, still 3-1. These ratios created what historian Edmund Morgan called a combustible situation. Young women, mostly between 15 and 25, worked in isolated households with men who owned their labor, their time, and controlled their access to food, shelter, and any hope of freedom. The correspondence of William Byrd, too, a prominent Virginia planter, casually mentions rogering the housemaid in the same breath as discussing tobacco prices. His diary from 1709 to 1712, preserved at the Virginia Historical Society, treats sexual access to servant women as a mundane privilege of ownership. The first warning signs appear in the earliest court records. In 1624, just 17 years after Jamestown's founding, the Virginia General Court heard the case of a servant named Catherine Watkins, who testified her master used her as his wife. The court took no action against him. In 1629, Chesapeake records show Thomas Hale was ordered to do penance for getting his servant pregnant, but the servant, whose name isn't recorded, received 10 lashes and extra service time. The pattern was set. A master's sexual access might bring mild embarrassment. A servant's pregnancy brought punishment. Colonial law transformed biology into bondage. When a servant became pregnant, she couldn't work during late pregnancy and early motherhood. Courts throughout the colonies adopted the same solution. Charge her for the lost labor. Maryland's 1658 law formalized this, requiring pregnant servants to serve their masters an additional 12 to 24 months after their original term expired. Virginia enacted similar statutes in 1662. The law created a perverse incentive structure. Every pregnancy extended a master's free labor supply. Court records show masters understood this arithmetic perfectly. The Somerset County, Maryland court proceedings from 1664 to 1668 contain 19 bastardy cases involving servants. In 16 of them, the servant accused her master or a male family member. The judges believed the women in 3 cases. In 13 instances, they ruled the servant was lying or consented. Additional service time was added regardless. Historian Terry Snyder's analysis of Virginia court records from 1640 to 1720 found that servants who named their masters as fathers won their cases less than 20% of the time. The ones who named fellow servants or free men fared better. The evidence suggests many women learned to lie strategically, naming anyone except the man who actually held power over them. But newly analyzed testimony from the 1681 case of servant Anne Orthwood reveals how little choice mattered. Orthwood arrived in Virginia in 1680 and was purchased by William Kendall. Within months, she was pregnant by Kendall's nephew John. Her depositions, recorded before she died in childbirth, describe being overcome after rejecting his advances multiple times. John Kendall admitted the child was his. The court ordered him to pay child support of 800 pounds of tobacco. Anne Orthwood's estate, meaning her grieving family back in England, was ordered to compensate her master for lost labor. She died owing her rapist's family. The numbers in parish registers tell the statistical story beneath individual tragedies. St. Mary's County, Maryland records from 1658 to 1705 show that servant women were 3 times more likely to bear children out of wedlock than free women. Historians initially interpreted this as evidence of servant women's loose morals, an interpretation that lingered into the 1970s, but demographic analysis by Lois Greene Carr revealed something else. The gap between servants and free women disappeared entirely when controlling for one factor: whether a woman lived in her employer's household. Free women who worked as live-in servants showed the same illegitimacy rates as indentured servants. The common variable wasn't poverty or class. It was proximity to men with power. The court testimony of servant women preserves moments of impossible choices in bureaucratic language. In 1692, Elizabeth Dickinson told the Henrico County, Virginia court that her master forced her in the cornhouse. The judges asked why she didn't scream. She answered that he threatened to add 5 years to her service if she told anyone. The court added 2 years for fornication. In 1698, servant Sarah Dodson of Lancaster County testified her master took her against her will in the tobacco field. 2 witnesses confirmed they heard her crying. The master was fined 500 pounds of tobacco. Dodson received 20 lashes and 1 additional year of service. The court records don't explain the logic. They didn't need to. Everyone understood the system wasn't designed to protect her. The physician's reports and midwife testimonies that appear in scattered court cases reveal the physical brutality beneath legal abstractions. When servant Catherine Bean appeared before the Northumberland County Court in 1679, the attending midwife testified she found evidence of violent use and that Bean nearly perished of it. The master denied everything. No witnesses were called on Bean's behalf. She was sold to a new master to work off her additional service time and the court costs. The court recorded her sale price, 1,200 pounds of tobacco, significantly less than a healthy servant's market value. Someone noted she was damaged goods. Some women fought back through the only channels available. In 1656, servant Catherine Rowe of Northampton County, Virginia, filed charges against her master for rape. The court interviewed her repeatedly over 3 sessions, an unusually thorough investigation. The judges ultimately ruled in her favor based on testimony from neighbors who heard her screaming and found her bloodied. Her master was fined and required to grant her immediate freedom. It was an extraordinary victory. It was also nearly unique. Historian Sharon Block's survey of over 900 sexual coercion cases in colonial records found fewer than 25 where servant women won freedom as compensation. Catherine Rowe's case was cited in later proceedings, always as the exception that proved the rule. Most women didn't have neighbors close enough to hear them scream. Plantation layouts isolated servants in outbuildings, kitchens, and attics. The archaeological record from colonial Virginia plantations shows servant quarters positioned to maximize surveillance by masters while minimizing interaction with other households. This wasn't accidental. As plantation sizes grew through the 17th century, so did isolation. Historian Lorena Walsh's analysis of probate inventories shows that by 1700, the average Chesapeake plantation housed fewer than 8 people across hundreds of acres. A young servant woman might go weeks seeing only her master's family. For 2 centuries, historians treated colonial sexual violence as a marginal issue, the unfortunate excess of a few bad masters in an otherwise functional labor system. Then, in 1978, researchers began systematically analyzing something hiding in plain sight: birth records. Parish registers throughout the colonies recorded not just births but timing. When historians like Lois Greene Carr and Lorena Walsh began calculating conception dates for servant women, a pattern emerged. Servant women's illegitimate births clustered 9 months after specific, predictable events: the death of a master's wife, the master's return from travel, the arrival of a new servant. These weren't random. The timing indicated calculated opportunity. The most damning evidence came from Middlesex County, Virginia. Between 1673 and 1750, court records show 47 cases where masters were directly accused of impregnating servants. In 41 of those cases, the master had recently become widowed or his wife was seriously ill. Historian Kathleen Brown's analysis concluded these men weren't simply taking advantage of opportunities. They were waiting for them. Then there's what happened to the children. Maryland and Virginia law stated that children born to servant women inherited their mother's status and served the mother's master until age 21 or 31, depending on the colony and the child's race. Plantation inventories list these children alongside livestock. A 1687 estate inventory from Charles County, Maryland lists 1 Negro man, 2 servant women, 1 breeding sow, 3 children of servants. The children had no names recorded. They were valued at 400 pounds of tobacco each. Genetic evidence has recently added another layer. DNA analysis of descendant populations in Tidewater, Virginia, shows unexpected ancestral patterns. Families who trace their lineage to free colonial women show typical genetic diversity. Families descended from servant women show significantly higher rates of Y chromosome matches to prominent planter families. The sexual exploitation that court records documented left a genetic signature that persists 3 centuries later. The system finally collapsed, not because it became less brutal, but because it became less economical. As African slavery expanded in the late 17th century, plantation owners found they could purchase lifetime ownership instead of temporary servitude. By 1700, the ratio of enslaved Africans to indentured Europeans in Virginia had reversed. The same sexual exploitation continued, now with even fewer legal protections for the victims. Some of the women in these records left traceable legacies. Catherine Rowe, who won her freedom in 1656, appears in land records purchasing 50 acres in 1661. She married a free man, had 3 children who survived to adulthood, and died in 1689 with a modest estate. Elizabeth Greene, whose case opened this story, disappears from records after 1664. No death record. No estate inventory. No marriage license. She served her extended time and vanished. The masters faced few lasting consequences. Robert Clocker, who impregnated Elizabeth Greene, served on the Charles County Court by 1670. William Kendall, whose nephew impregnated Anne Orthwood, became a burgess in the Virginia Assembly. The system protected them because they were the system. The legal principle that allowed masters to add servitude time for pregnancy survived in modified forms for centuries. As late as 1840, court cases in northern states cited colonial-era precedents about servants compensating masters for lost work time due to pregnancy. The idea that a woman's reproductive capacity created debt to her employer didn't die with indentured servitude. It adapted. Here's what keeps historians searching through archives. The documented cases represent only servants who made it to court. Most didn't. Colonial courts required witnesses, travel to county seats, and the ability to withstand interrogation designed to discredit the accuser. For every Elizabeth Greene whose testimony survived in court records, how many others endured in silence? The Maryland State Archives contain over 12,000 probate inventories from the colonial period. Hundreds list servant women by name. Thousands of births appear in parish registers with fathers listed as unknown. Researchers are still cross-referencing these documents, finding matches, discovering patterns. Each new dissertation uncovers another dozen cases that previous generations of historians filed away as unremarkable. The darkest detail might be this: the system worked exactly as designed. It funneled desperate people into conditions where exploitation became routine, then punished them for being exploited. And everyone in power knew. The laws weren't accidents. The court decisions weren't anomalies. This was the documented, deliberate architecture of colonial labor. The evidence is in the archives. This is Blood and Empire. We'll see you in the next one.